Okay. Mr. Barak or Barrack, I don't know how to pronounce your name.
We pronounce it Barrack, like the Army building, Your Honor.
Okie doke. You're up, Mr. Barrack.
Thank you. May it please the court, Ryan Barrack on behalf of Tara Lombardi, the plaintiff appellant in this case. I would like to reserve 5 minutes for rebuttal. Thank you, Your Honor. We are here on an order granting summary judgment on the issue of whether a professional employer organization, a PEO, was a joint employer under the Florida Civil Rights Act and the Americans with Disabilities Act. We ask the court to reverse the trial court and allow a jury to determine whether or not Encore was an employer. If there was ever a case where a PEO, also known as an employer leasing company, was an employer, this is that case. And at the minimum, a jury should be making that decision. Encore was a PEO. And to be clear, Encore was not just an employee leasing company. Rather, the evidence showed that in this specific case, they were much more involved in the employment relationship than any payroll company would be, or than a normal PEO would be. Pavamento was the other employer of Ms. Lombardi. Pavamento did not have an HR department. They didn't have other HR employees. They had Encore. Pavamento's owner described Encore as their HR department. Pavamento relied upon Encore for compliance with federal and state laws, reporting of vacation, discipline, hiring, termination, and unemployment. In this case, Encore expressly laid out its employment relationship with Ms. Lombardi in a written agreement called Terms and Conditions of Employment. It's a written contract.
Ms. Lombardi was Barrack, is it correct that she was not aware that they were in the picture until after her termination, correct?
Well, there's two terminations, Judge LaRose. There's the termination, which again further supports the notion that there were two employers. She was terminated originally by Pavamento on September 13th. And then on September 30th, she gets terminated again by, well, after September 30th, she's terminated again by Encore when Encore writes her letter and says, contact us so we can reassign you to another work site because you are our employee.
And even though she said she wasn't really aware of Encore, there is the form she signed that said she was Encore's employee, correct?
Absolutely.
Which I suspect probably she just was put in front of her and she signed it without really perhaps realizing its import. Is that?
That's right. And the evidence also shows that while she might not have consulted with Encore necessarily during her employment, she certainly could have. Pavamento did consult with Encore about her employment and about the termination decision. After she was injured, she was involved in a car accident and was an amputee. And after she was injured, Pavamento's president testified that he did contact Encore and spoke with them about bringing her back to work and ultimately her termination. And let's be clear, she was back for 1 day after her amputation and then was terminated the next day from Pavamento. And then
we have a dispute as to that, as to whether there was any dealings between the two, your joint employers.
So there is a dispute as to that. I mean, Pavamento says, which again, summary judgment is not appropriate, right?
Yeah. So your charge here, I guess, is to demonstrate there's a factual dispute in the record as to whether Encore was this lady's co-employer or joint employer.
Correct. And that is ultimately a jury question. And especially in this case, because there are disputed issues of material fact, there are really two issues, two primary things that are disputed, that Encore disputes. That one is Pavamento's president says specifically, I contacted them, I spoke with them, and they say that didn't happen.
He was somewhat equipped. Couldn't remember who he spoke to, I suppose, but he was pretty sure that he called, correct?
Correct.
Is that accurate?
That's right. And I think, and I mean, he admits that he called, and the fact that his memory fails as to exactly what it is he's discussed is really a question for the jury, because they could conclude that he's sort of, purposely being unclear as to what his memory is because those facts would hurt him. But they can certainly, but he doesn't speak that call.
If you play it out, the facts seem to suggest I called Encore. I wanted to know what to do. And the response is, well, number one, I don't remember. If I did remember, I would advise not a good idea.
Well,
That's how it plays out.
well, that's what, but then just to be clear, after the Encore letter, when she contacts them, there's another dispute about what happens. She says Encore told her that there was no place for them to place her because she was disabled and in a wheelchair, that there were no other employment sites for her to be placed at. And that's what she says they told her. And Encore admits that they tried to find her other employment, but they say they only tried to find her other employment at Encore itself.
But at the time of her employment, she's hired by Pavimento. And after she's hired, Pavimento then, I guess, goes to Encore and does whatever it does to use their PEO services, basically, right?
Well, and again,
That's how it works.
So Encore hires her.
But I want to understand. Let me try to understand the timeline here. Did Pavimento and Encore have a relationship, or contractual relationship prior to the hiring of your client?
Yes, they were. They had a contract together.
So Encore didn't inherit an existing employee at Pavimento. She was from the beginning, at least from Pavimento's perspective, an employee of Encore.
That's right. And by contract, she was an employee of Encore. I mean, words have meaning, and that contract is clear. That
this document was presented to her to sign, if I recall, after she started her employment, but I was within a few days, I guess.
Right. I mean, so as in almost every employment circumstance, you start, and then on day 2, they come to you with the W-9, everything else. And here, I mean, she was Encore's employee. Encore was responsible and did pay her. And they were responsible for ensuring that she was paid at least the minimum wage and overtime for hours worked. They issued her W-2. They issued her paychecks. They had the drug-free workplace policy.
Well, Mr. Barrett, can I interrupt you on that point? Because you trigger something. A PEO typically has a menu of services that it offers, correct? And
some do, yeah.
Okay, and some companies like Pavimento might say, I just want you to do my payroll and make sure I have workers' comp in place. Correct?
Sure.
Now, suppose Encore provides the full panoply of services, including HR, advice, guidance, but the alleged co-employer does not take advantage of those services. Does Encore now remain liable as a co-employer? I'm getting, so for example, suppose the owner of Pavimento basically said, you're fired. I didn't make use of these services that were otherwise on the menu. Can Encore be held liable?
So I think that to some degree, you're looking at, it becomes a fact-specific inquiry and the totality of the circumstances, right? And that's ultimately a jury question as to the totality of the circumstances and what it is happened in this instance. And in this instance, the totality of the circumstances support that. Is it possible?
If following through on that, assuming the scenario that Judge LaRose, the hypothetical that Judge LaRose posed to you, assume that was the case, undisputed, but there was a document that the employee was given a sign that says, you are an employee of the PEO. Does that create a fact dispute?
It certainly creates an element that would need to be looked at. Is that automatic? Does that give summary judgment to the employee?
To be weighed by a fact finder?
Yes, to be weighed by a fact finder, right? It is not dispositive of the issue to summary judgment for the employee, but it's absolutely an element that needs to be considered because it's something that weighs heavily on the fact that this is in fact an employment relationship between these entities. And I'm reminded sort of the independent contractor type thing. Just because there's a contract doesn't necessarily mean that someone is an independent contractor, but it's an element that should be considered. And here, this existence of this agreement is one of many of the elements that support the fact finder making the decision as to whether or not Ms. Labardi was an employee of Encore. I'm not saying in every instance a PEO is not the employer or is the employer, but in this case, under these facts, the jury should be making that decision. The totality of the circumstances in this case suggest that the jury should be making that decision. And again, when you look at this, there are the key things, 2 different termination dates. And Encore specifically contacts her and says, we're going to try and reassign you. And if we can't, it could impact on your ability to get unemployment benefits. PEOs don't just exist to dodge the ability to pay unemployment, right? They exist for an actual reason, which is they are the employer. And in this case, she was in fact employed by Encore. Now, 2 things that I think are
Do you agree that it's the meaningful control test would apply?
So I think meaningful. So there's 2 Florida cases that sort of talk a little bit about this, which are Diaz and Martelonich are sort of the 2 Florida cases. But all of the cases really, and they would go back to cases under the NLRA, and they all really sort of talk about the totality of the circumstances and sufficient control, which maybe that's a parsing of words in terms of meaningful, but it's sufficient control, I think, is really the Browning-Ferris language. And again, we're getting sort of deep into National Labor Relations Act cases, some of which we discussed in brief.
You know, if that, when you consider, like in going back to this agreement or employment document, the fact that it separately imposes a workplace drug policy by Encore, would that be meaningful control?
Absolutely, right.
Okay. And then let me go, refreshing my memory here, looking at your complaint. You alleged in the complaint that the actions of Pavimento by terminating her violated the ADA, was discriminatory. But you also alleged separately that Encore's actions thereafter and failure to place her with knowledge of her disability was an ADA violation.
Yes.
Correct. So does it need to be a joint employer at that point with Pavimento in terms of that potential liability?
Right. That's exactly it. Under the circumstances of this case, there were actions that Encore itself took
after the employment with Pavimento had been terminated.
Right. But
if you go down that route, you potentially have a problem with the extent of your damages.
Well, that's a jury question, right? To argue about as to.
I'm just pointing out. I mean, if it's Encore's independent action, there may not be any liability for damages caused by the Pavimento termination, right?
I mean, if we pretend that conversation didn't happen beforehand, but
yeah,
we think right,
okay.
Right.
Yeah, okay.
But what I'm saying is your complaint alleges more than one basis.
Yes, absolutely.
For the claim, both as to Pavimento and Encore, because if they're co-employees, is Pavimento liable for Encore's violation thereafter?
Well, again, it would be an interesting. So the
Right.
matter that claim has been resolved. So I
get it.
don't opine on that.
Yeah.
But I think that there is a
that was hypothetically that was not the case, and you went to trial with both of these defendants.
Oh yeah.
With Encore's actions after the Pavimento termination fall on Pavimento as well as a co-employer, as a joint employer.
I mean, realistically, for as how it would play out in trial, I think there would be a lot of sort of pointing fingers
Yeah,
at each
probably.
other.
Yeah.
They did this, I did this, we did this. It would be certainly an interesting, and will be hopefully when we get remanded, an interesting trial on these issues.
Okay. We have helped you use 15 minutes of your time, Mr. Barrick. So proceed.
I will defer to my learned counsel on the other side, and I'll come back after she's done. And if you all have additional questions for me, I'm happy to answer them.
Okay. Thank you. All right. You're up, learned Ms. Fiore.
Good morning, Your Honors. May it please the court. I am Kristen Fiore here today on behalf of Encore PEO. So there was a lot of discussion. I'm just going to try to respond to some of it. First, I think it's important to understand here the terms because it gets confusing and they get mixed up a lot. So there is a difference under the law between the term co-employer and joint employer. Okay, for purposes of these claims.
And obviously we seem to be using them interchangeably. And
that's common. That's common. So, but in this context, they are different. So if you look at page 1426 of the record, that's Mr. Rawls of Encore's testimony, he kind of explains the difference and explains that in this situation, Encore PEO was acting as a co-employer, which would not have the type of control necessary for to give rise to liability under these particular statutes. Now, the position of Pavimento on the other side was that sufficient control is enough, and that's not the standard. If you look at the case Amiable from the 11th Circuit, it says we're talking about direct and substantial control here. So Encore PEO did not hire Ms. Lavardi. They did not set her pay rate. They did not give her work assignments. They were not involved in her promotions other than to process the the pay raises that were corresponding to them. The key is whether the alleged joint employer, so here the alleged joint employer is Encore PEO, whether or not they had direct and substantial control over the terms and conditions of Ms. Lavardi's employment. And the record it's undisputed that there's no evidence in the record to support that relationship. I think that
there is the employment, whatever that document is. It's referred to as an agreement, but this doesn't seem to be signed by anyone on the other side. But it does set forth Encore's workplace drug policy.
Mhm.
Seems to me to be imposed upon her by the entity that is identified as her employer in the document.
yes, and
That-
it would go ahead, I'm sorry.
Isn't that control?
No, because for two reasons, and I was going to get to the whole issue of the use of the word employee. So I will get to the drug place in just a moment. I just, in order to set the stage for that.
I need to interrupt your flow.
Oh yeah, no, you're great. First for the drug place, I'll get back to the drug place
But
policy.
the drug place, as I understand it, would be consistent with Encore providing workers' compensation coverage. Because
Correct.
to get the discounts, you have to be you have to make sure your client is a drug-free workplace.
Right, and I think that's where it comes into understanding.
That could mean that you subject yourself to the legal ramifications of that employment.
Right, and respectfully, if you read through the cases that are cited in the briefs, their briefs and ours, the cases from the federal courts, most of them 11th Circuit, the subjecting yourself to the policy of another employer, co-employer, is not determinative of the whole case. If you look at
but I mean, we're on summary judgment in your favor, so that whether it's determinative is not the question. Whether it creates an issue to be considered by the jury is another. But again, following on Judge LaRosa's point. So you have a PEO that wants to get the workers' comp discount, and so it imposes this policy on the employee. So arguably, they have a choice. They don't want to subject themselves to the panoply of liabilities they can have as the employer, or they get, they don't want to do that, or they want to get the workers' comp discount. So they weigh that decision. It doesn't necessarily, the fact that they have this other motive doesn't necessarily remove them as the employer, does it?
Well, that's Pavimento. So Pavimento makes the decision.
Or
Give the well, no, because it's not a workers' compensation policy to which Encore is a party. Encore is just an administrative provider.
all I'm saying though is Judge LaRose suggests that the purpose of the workplace drug policy in the Encore agreement was motivated by a workers' comp discount issue.
It could be one purpose. It's not in the record what the purpose was. I do want to speak to the issue of the word employee, because I think it's important. And I would encourage you to look at the case Peppers, Lampalus, Morrison, and Longstreet. All four of those cases explain why the use of the word employee or that title is not a consideration in the question of whether there was direct and substantial control. So in the Peppers case, they explain there's a difference between the word employee and being an employer for purposes of the anti-discrimination laws. In Lampalus, they say that these particular statutes these remedial statutes that we're dealing with do not protect mere titles and labels like employee. We're not focused on the everyday conception of the word employee. And that's why it gets a little confusing, because when you come to these cases without the framework of what is the difference between a co-employer and a joint employer under these laws, you can be someone's employee, but that does not make you a joint employer for the purposes of subjecting you to liability under the statute. And I want to refer, before I run out of time, to the question.
You still have about 13 minutes left.
Okay.
Yeah,
It's hard to tell when you're talking.
let me clarify something in this regard. Both of you have cited cases from that deal with other statutes, not the ADA, right? And am I correct that there is not a specific ADA statute or reg that controls? So you're using analogous case law for other anti-discrimination statutes, correct?
Correct. Although I will tell you, there's a case that I submitted a supplemental authority only for the purpose of refuting a point that came up in the reply brief. I recognized it was available before I submitted my brief. The reason I did that is that Parker case is an ADA case and a Title VII case, and they use these factors, same factors. And there's all kinds.
I did have a chance to quickly glance at it, but I didn't fully appreciate that it was an ADA case.
Yeah, it is. It's a Title VII and an ADA case, and they don't usually get into, sometimes they look at the actual language of the regs to determine, but the question of whether an entity is a joint employer is really a question of the totality of the circumstances, putting all these factors together. And these are, if you look at that amiable case from the 11th, it clearly says that joint employment is a question of law. I do understand that sometimes a factual issue may come up of material fact, but in this case is not one. Judge Northcutt, you had asked a question of Pavimento's Ms. Labarty's counsel regarding the second alleged termination here by Encore.
Yes.
You had asked, so what's important to understand is if you read Mr. Roll's testimony, who is the Encore representative, and it's at, I believe, 1426 of the record, he explains that there were no positions available for anyone to be placed in, not just Ms. Labarty, because the Encore PEO was just kind of getting into the employee leasing space of actually placing staffing people in different positions. It had previously just been, and this is all in his testimony, it had previously just been involved in providing these administrative support services to its clients. It was trying to foray into the staffing arena. And so when it got notification of Ms. Labarde's termination, which, by the way, the only way, it's also in his testimony, they found out that no hours were being reported for her. And so they called Pavimento and said, what's going on? And they explained what had happened. And so the system, whether it should have or not, is cut out this letter that says, you have been terminated as our employee, which again, the word employee does not mean joint employer. It kicks out this letter. Ms. Labarde calls in as instructed, and the Encore PEO folks, even let's assume they say, even if they did say we can't place you because there's a wheelchair, because you have a wheelchair, under the ADA and the FCRA, she has to prove for her prima facie case that she was qualified for the position she's alleging the discrimination about, but there was no position. If you look at Mr. Rawls' testimony, there was no position to place her in. There none, because they weren't offering these services yet. They were trying to, and so there can't be any discrimination for that second termination on behalf of Encore PEO because they didn't have any position to place her in, any person in. And so I just wanted to make sure that that was clear.
If we look to the actual termination by Pavimento,
Yes.
and let's assume Mr. Barrick's position, maybe we have a factual issue there. After day one, Pavimento decides to fire Ms. Labarde. Pavimento calls Encore, and I'm not sure the record reflects exactly what Encore told Pavimento from that side of the equation, but I guess the inference would be they said, fine, go ahead and do it. And if you look at Encore's position, which is, I don't remember, but if I did, I certainly would have said it's a problem. If we focus all this co-employers on that factual, is that material enough to defeat summary judgment?
I don't believe
Because
so.
under that scenario, with that fact issue, Pavimento, I guess, relied on advice from Encore to go forward with the termination.
Assuming that's what the record shows, and our position is that it doesn't. I mean, he
Okay.
multiple times,
I understand.
that's clear. He multiple times said, I don't even remember if we talked about termination, et cetera, et cetera. So let's just assume for the purposes of your question, it's our position that that is not enough to establish here that there was a joint employment relationship. That's not enough substantial and direct control of the terms and conditions of her employment throughout the entire employment process. And I think this Peppers case, again, I keep referring to it, but it's really instructive. This was a situation where the county, it was a county and a district attorney set up, where the district attorneys are technically county employees, but they're not. The court found that the county was not a joint employer of the specific assistant district attorney in this case, because there was not enough control, and they did the circumstances giving rise to the termination they had no control over that. Now,
does it make a difference? Does it make a difference that Pavimento asserted that Encore was in fact its HR department?
I don't believe so. If you look at the Third Circuit's case in the enterprise leasing case that's cited in the briefs, that is a case where enterprise, it's kind of similar. Unfortunately, there really don't seem to be any cases in this PEO context that either of us could find, but this enterprise leasing case from the Third Circuit is kind of close because it's a company that was providing all the HR advice and the compliance and all of that to the entities that were alleged to be, that were the actual employers in the case. And the focus in that case, they found, even though they got their HR advice from that from Enterprise, that was not enough to establish. I mean, there were other factors too. I want to be clear, because this is, this is really a case by case basis here. That was not a definitive factor in saying, okay, that's enough. If you get your HR advice from someone, that automatically renders you a joint employer.
Okay, so in summary, not in your argument, but for my purposes, you're saying that even though this agreement that she signed said she's an employee of Encore and that she has to comply with these, safety regs and safety requirements and workplace drug requirements and so forth, and says if you're an employee of Encore assigned to, and there's a blank there,
Mhm.
And that if we learn that you have been, I don't know, terminated or reassigned from them, then we'll send you this 72-hour notice, and you do when you learn of it, and you say you are no longer an active employee of Encore PEO, and you have to call us, and if you don't, it'll affect your unemployment benefits, all confirming that your employment is with Encore PEO. That does not contribute or create a fact dispute or an issue for the jury.
Yes, because as a matter of law, first of all, if you look at the PEO statute, and I'm sorry, it's escaping me. I think
Go ahead.
it's the provision is cited in the brief, but that they're required, I think it's 460 something, they're required to send this notice as a PEO. And I don't think that's enough, because of all of the cases that say that's the whole reason these PEOs exist. And so, if these PEOs operate in this way to provide these services, and they are not intended to take on the liability. And so I don't think
if the statute requires this sort of activity, does it say they do not take on liability otherwise? I mean, this is say, hey, there's another explanation for why they did this, but I don't see how the existence of another motive or explanation somehow excludes their potential liability under the ADA.
Right. What I'm trying to say is
it could be that if you make a choice to get into this business, you make a choice to subject yourself to these responsibilities.
Right. But even on this record, given the fact that they sent her this letter, they called her the employee, the mere fact, okay, let's just assume for the purposes of our discussion, Judge Northcutt, that let's assume just for the purposes of our discussion that you find that they are a joint employer. Okay. Then you can't get over, then we've got our tipsy coachman argument. As to our client, that they cannot, even if they were the joint employer, they cannot make a prima facie case of an ADA violation as to that second call, which is one of their grounds because.
But do they have responsibility for Pavimenti's alleged?
No, because it is not a vicarious or strict, it's not a vicarious liability statute, that because it's not an agency concept, it's not a vicarious or strict liability. No, they have to affirmatively, and if there were no positions at all to offer, then she could not meet the standard of the ADA. I did want to correct one thing before I went. I think earlier I did say that that Encore was not a party to the workers' comp insurance policy, and they may have been. And so I just wanted to clear that up. I don't think it matters, but just for the purposes of clarity. But no, I don't think that that's enough. And I think you have an alternative ground here that you can affirm on, because there's no evidence of discrimination in the record at all by Encore. And with that, if there's no other questions, I would ask that you affirm the trial court's ruling in Encore PEO's favor. Thank you.
Thank you, Ms. Fiore. You are learned indeed. So, Mr. Barrick, you're up to rebut.
You're on mute.
You're muted, Mr. Barrick.
Of course I am. And I had something brilliant that was going to resolve the case. When Miss Lombardi called, when she called them, and this is in the record at 277-2778. And when she called, she was specifically told that she wouldn't be able to be placed anywhere because she had a disability and they couldn't accommodate her wheelchair. I mean, that is the burden shifting analysis under the ADA and under the discrimination laws isn't necessary where you've got prima facie evidence that she was told there are no jobs for you here because you can't work here in any of these entities because you're in a wheelchair. So we don't get into the whole burden shifting analysis, all that other stuff. So the Tipsy Coachman thing doesn't apply. There's absolutely sufficient evidence for a judgment in her favor on the discrimination claim, even just on that second part of it.
Well, even if they said that to her, if it turns out there were no positions she could have filled, would that make a difference?
Well, I mean, there's no evidence that, in fact, they contacted all of the entities to see if there was any place. He said, "Oh, well, we don't do that."
Which is talking about the Rawls deposition.
Yes, that's Mr. Rawls' deposition. He said, "We don't do that," but she said they told me that there was no place they could put me because I was in a wheelchair. I guess I want to correct one thing, and we cited this in our reply. Diaz versus Impacts of Doral, which is a third DCA case, is an employee leasing case. And in that case, the third DCA reversed the trial court on the joint employer issue. The trial court directed verdict for the joint employer, and the third DCA reversed and said, no, the joint employer, that's a question for the jury to decide. That's a whistleblower case, not an ADA case, but it's a Florida Whistleblower Act case. And that relied on another prior third DCA case, which again talks about it's the totality of the circumstances, and that's the Martin Olich case, which is again is another third DCA case. And that case talked about cites to other cases which talk about sufficient control. And that's really the buzzword, and totality of the circumstances, sufficient control. The cases really talk about if we have two separate entities, but they share or co-determine matters. And here that's exactly what happened. And especially in the specific instance of this case, we're looking at these facts in this circumstance where we've got some extraordinary things that happened. And under these facts, it is a case where an Encore was an employer of Miss Lombardi. So we ask that the court reverse the trial court, remand us back, and allow this matter to go to trial. In conclusion, I would say words have meaning. There's an agreement here. There's also facts have meaning. There were specific factual allegations, specific things alleged that happened on which there are material disputes, and that is sufficient for us to get to a jury. A PEO is not just a way of dodging unemployment benefits. Sometimes an employer is an employer, and this is a case where an employer is the employer. The matter should be reversed and remanded for the jury to determine. Thank you, Your Honors.
Okay. Thank you both. It's an interesting case. Well argued. So
Thank you.
in order to leave, you press the button called leave on the Zoom.